Bodycam. In the meantime, we're in Virginia watching the civil trial over the shooting of a teacher in a school by a 6-year-old student. Teacher is suing the assistant vice principal. And with the first witness on the stand, they are showing some body camera footage of victim Abby Zwerner after she was shot. So I do want to warn you, there is going to be some blood in the video. So if this is something that's going to be upsetting for you or hard to watch, I want to just warn you now before we go back in.
You got a phone with how many you don't need her out. They got 5 on right here.
There's a bullet in her hand and it looks like in her shoulder. Okay. And it's nothing on the other side. Okay. And it didn't come out of her hand either. It's in her hand. Okay. We're going to take care of her, okay? Medics are on their way in.
Around the corner, okay?
We need to look to see, did it exit? No. How many times was she shot? How many gunshots did you hear? One.
Gunshot, okay?
Sorry, ma'am. We're going to get up close and personal with you, okay? Please.
You're okay.
Got actively bleeding right now.
Nothing on the lower.
Okay. I'm going to roll you over a little bit, okay? I want to see if you're clean now. Okay. Go ahead and lift your arm a little bit. Okay. I'm with Mom. Are you moving anywhere else?
Yep.
Police officer.
Yep.
Tell me your mom's number. You want the phone, sir? Yes.
To the office.
Hey.
What's your name?
Abby Zwerner.
25. Do you have a history?
That's the first clip, Your Honor. There's 3 clips. Okay. So I don't know if Your Honor would like to take them one at a time.
So what number has this clip, or are we giving this clip?
110A.
Plaintiff's 110A. Did you want to go clip by clip, or you want me to watch all 3 and then you can respond? You have a preference?
I think it would make sense to do one by one, Judge, because the argument's different.
Okay.
Judge, may it please the court. With respect to this particular video, I think there's a number of problems in why it should be rendered inadmissible. The first is that, first and foremost, under Rule 2403 of the Rules of Evidence, evidence is inadmissible even if it is relevant, if the probative value is substantially outweighed by the risk of unfair prejudice, misleading or confusing the fact finder, here the jury, or it is needlessly cumulative. This runs afoul of the needlessly cumulative prong, as well as the risk of unfair prejudice in misleading or confusing the jury. With respect to the cumulative nature of this video, Judge, you will hear in the course of this trial, and we already have fact witnesses testify that Ms. Zwerner suffered a gunshot injury. We've heard a medical expert come and take the stand and testify under oath in detail regarding the specifics of that injury. The jury has reviewed demonstratives depicting how she was injured, the seriousness of that injury. All this evidence has been established already. Numerous fact witnesses have also testified to the impact of that injury on Ms. Zwerner, as well as her family. And so we already have competent evidence before the jury on these points. This evidence would only be probative of establishing the nature of the damages, if any. And here, given the existence of competent evidence on that point already, any probative value is minimal at best. In contrast, the risk of prejudice to the accused is unfair and substantially outweighs that probative value. Because you can see, it is difficult to watch this video. It will have a strong impression on the jury. And of course, the jury is entitled to consider the evidence. They should understand and hear competent evidence that is probative of the material issues in dispute. And of course, damages are at issue. I acknowledge that. But this video is inflammatory. It is likely to incite sympathy. It is likely for the jury to render a verdict based on those improper grounds. The authority is well established. Those are improper grounds. And I also acknowledge that under Rule 2403, and the court's well familiar, the court may issue a limiting instruction to try to mitigate some of those risks. But I think that in this particular case, Judge, given that we already have competent evidence addressing these exact issues, this is so inflammatory that the jury would not be able to compartmentalize. You can't unring the bell once you see and watch this video. And given that circumstance, I think that it cannot be cured by a limiting instruction. The risk is too great, especially in this case. We will hear from other experts as well, I imagine, on medical damages and the nature of injuries. And so, again, this is cumulative. It fails Rule 2403 balancing, and it should be excluded. The final point, Judge, is to the extent that there are statements on that video attributed to Ms. Zwerner or anyone else, to the extent that is offered for its truth, I would object on hearsay grounds and ask that it be excluded and not considered by the jury.
All right, court overrules your objection. It's more probative than prejudicial. It's not cumulative, and it is not hearsay. Next.
110B, Your Honor.
Hey, so we're gonna pick you up on camera and get you on the stretcher? Move your arm all right?
She has a bullet in her hand.
Okay. All right, well, you're doing just fine, okay?
Does she have something in her hand?
I have the shoulder, yep. 1, 2, 3, up.
Alright, I'm coming out. I'm getting the medic.
You allergic to anything? No? I need to ask what's the matter. Any older victims? No older victims here? No. I need a little room.
All right. I'm not sure why we split that clip up, but...
I understand, Judge. There's a third video that's slightly different, but I rest and stand on my prior arguments.
Okay. Yeah, and I would like that. I'm going to overrule the objection. Objection noted for the record, contemporaneous, and I would like that be one clip.
Your Honor, they're different in time. That's why we split them.
There's something cut in between. There's
Correct.
a cut in between.
And the thing that was cut in between was a conversation about the minor, which is why I cut it.
So you can't show it as well. I mean, you could just press the next clip.
I could just press the next clip, and we could admit them as exhibits, as a single exhibit number. I don't want to mislead the jury to think that those two things happen in the same moment, though.
All right.
Okay, so the jury's out of the courtroom. You probably gathered that. They're previewing these clips for the judge, the defense attorney raising some concerns. He's raising some concerns about hearsay in the video. Okay, so fair enough here. Let's bring in our legal analyst guest, Attorney Franz Barkhardt, and see how he thinks the judge is going to rule here. Franz, your thoughts on that? There are no doubt hearsay statements here, but doesn't mean it's inadmissible hearsay. We just have to do analysis on what's said. How do you think the court's going to come down here with the plaintiff's statements in the video clips?
I think it all comes in. I think it's present sense impression. It's what she said in the moment. You know, there's an argument for excited utterance, but I don't know that works. But look, this is not a criminal case. She's subject to being called by either side as a witness, and she's subject to cross-examination. So I don't know that it's being offered for and we're using legal phrases, Julie. I don't know if it's being offered for the truth of the matter spoken as much as that it was spoken. And look, good objection by the defense. He might as well have said, Judge, we object because this makes the plaintiff look very lovable, and that hurts us. And you do that to make a record. You don't expect to necessarily win that objection, but you have to object to it. So if anybody's out there is wondering, like, why did they object to that? That's something that a jury should see. They're doing it because it's good lawyering. It's protecting the record.
Sure. Yeah. They've got to advocate for their client. That's for sure. Tell me, in terms of seeing this video, how impactful is this going to be for the jury when they see her bleeding, just shot? I mean, you can see her, you can see the pale, I mean, like just her face, she's in shock. I mean, I'm no medical expert, but seeing that, and then she's saying things like, tell me a story, distract me from what's happening. How do you think this is going to resonate, Franz?
So there's a rule with juries. Don't tell them that which you can show them. And this is a principal example of the best evidence of what that poor woman was going through in real time is that video. So show the jury, I mean, she looks totally different right now. She's a beautiful human being, but there's just something that's lost with the phrase, oh, she was shot, versus being able to see that video and being able to realize this woman is unsure what's happening. She's unsure what's going to happen to her. There's no certainty that she's going to quote unquote be okay. So that video is more powerful than any words that she is going to offer to the jury when she testifies.
I couldn't agree with you more, my friend. And for anybody who missed it, we saw Abby Zwerner walking out before they previewed the clips. She did not watch them in the courtroom, and I would expect that she's going to stay out when they bring the jury back in so that she doesn't have to relive that trauma. Franz, wonderful having you this hour. Go win some cases. We'll see you soon. Friends at home, we'll be right back.
I just remember her facial expression. It was kind of like a look of shock.
And is that one of the reasons you didn't have a good feeling?
Probably.
Did you hear the shooting?
Yes.
Okay. Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
And where did you think it had come from?
Abby's room.
Welcome back to Court TV Live. I'm Julie Grant. We're in Virginia in the case that made national headlines when it was made known that a 6-year-old child shot his teacher in her classroom. This is back in 2023. Fortunately, that teacher survived. And now she's in the middle of a civil lawsuit. She has sued the vice principal of the school. She's alleging gross negligence. What we just left off with in our last hour were some video clips being played outside of the jury's presence. And we saw the plaintiff leave the courtroom so as not to see herself in what is police body camera footage when first responders arrived to treat plaintiff Abby Zwerner after the shooting. So I do want to warn you, these videos are graphic to the extent that you're going to see some blood. You're going to see her face in some of them, and she's lying on the floor being treated and then taken out and transported by ambulance. And so if you think you might find this upsetting, turn away now. Let's go back in.
And if I may, Your Honor, it'll help with the witness to be able to go through one clip, play the next clip, and then the third clip.
All right, I'll allow that. Contemporaneous objections. All right, and said court's ruling is the same as on Exhibit 110A. All right.
110C now, Your Honor.
Wait, we just did 110B, I thought.
C.
C now, okay.
You okay, Abby? Everything's gonna be okay. They're gonna take really good care of you.
What's that?
Yeah. Tell me a story. Yeah, of course. Do you have any pets? Yeah, what kind of pets do you have? What's the cat's name? Yeah? How old is your kitty cat? 3. I got a dog. His name's Abby. And he's a turd right now, so he won't get his ears cleaned by the vet. He like runs and hides from us. Yeah? I also have a hound. He's pretty loud.
seeing the clip.
If I could just argue from the council table.
You may.
With respect to this.
Speak up a little, please.
Yes, Judge. With respect to this particular clip, I stand on the prior objections based on 2403. But in addition, why I wanted to single this one out, Judge, is because this one has extensive inadmissible hearsay in it, more so than the other clips. It would be appropriate for Ms. Zwerner to take the stand and testify to some of the details she had here, but this cannot be backdoored. There's no applicable exception. They have the burden of establishing that. So I'd ask it be excluded.
You have a little more of an uphill battle on this one. You know, both the words and I guess the video itself. So I'll hear you.
Your Honor, the pertinent nature and the reason we selected this one in addition to the other two is first, it demonstrates a different period of time, all of which in terms of the timing needs to be considered by the jury in determining the adequacy of their verdict. Number two, and onto the issue of hearsay, there's a moment in the video in which Ms. Zwerner says, "Can you tell me a story?" And that is not a pertinent fact in this context of we need that for the truth. But what it demonstrates, even if it is offered for the truth, is what 8033 permits, which is it demonstrates her then existing state of mind, that she is trying to distract herself of the experience that she is enduring in that moment. And then all the statements and the conversations that flow from that, whether her cat's name is Jack or Jill, and whether the dog's name is true or untrue, is not the substance that's important. It's the fact that in that moment, the severity of the circumstance as depicted by the video and by the conversation, which is to try and distract her from her experiences as she's going through them, demonstrates what is an element to be considered by the jury, which is her mental anguish throughout this process, that it was taxing on her to the extent that she affirmatively requested, "Take me away from here and tell me a story."
At this point, it's more prejudicial than probative. Now, if she testifies and it can be used for another purpose, I might allow that. So at this time, through a witness other than Ms. Zwerner, I'm going to sustain the objection.
Yes, sir.
However, I give you leave to try to introduce it again after or during Ms. Zwerner's testimony.
Yes, Your Honor.
All right. Exception noted. All right. Any other issues to take up?
No, Your Honor. With the court's permission and opposing counsel's permission, I'd like to go and inform the witness of the ruling so that she knows which two clips will be played.
All right. Any objection to that?
No, Your Honor.
Okay. All right. So we'll take hopefully a brief recess. Brief recess, and then you just let Deputy Hopkins know, and we'll come right out, have the jury set, and we'll start our day.
Yes, Your Honor.
Okay, perfect. Thank you all.
Please rise.
Okay, so here's what's going on there. The judge is limiting the hearsay with respect to this point in time in the trial, where this witness is going to be introducing these exhibits, the body camera footage, and there's some talk on there where the plaintiff says, "Tell me a story. Somebody tell me a story," while she's being treated. And you heard her attorney saying that was because she wanted to just get her mind off of the gunshot wound and all the chaos that was happening. And she starts talking about her animals, talks about having a cat, small talk. And the defense wants to keep this hearsay out. And you heard the judge, he thinks it's more prejudicial than it is probative. However, he said, if you call your client, you can ask her about that. She can explain why she made the statement, "You tell me a story," during this traumatic event and what her then existing state of mind was. So hearsay is tricky, and I have to say I commend the defense team for speaking up and identifying things that are hearsay and subject to analysis and exclusion, and we're seeing the court do just that. So while they're on a break, let's back the truck up a bit and talk a little bit more about the events that led up to this. This is an issue that many people, myself included, feel could have been prevented because of all the red flags that were raised. This child who brought the gun to school had just come off a suspension. He had a history of violent episodes. He was supposed to have his parent with him throughout the school day. That's how bad his behavior was. But on this given day, his mother was not with him. We also had him showing the firearm to another child in the class who reported it to a teacher. We have teachers reportedly seeing him taking the gun from a backpack, possibly putting it in his pocket, and all this related to the vice principal. yet the child's person wasn't searched. Let's talk about this with our law enforcement analyst guest, retired FBI special agent and firearms expert, someone who does training all the time on firearm safety and use, Jennifer Coffindaffer. Jen, good morning to you. So let's start with the lack of the search of this child's person. I'm sure you have a lot of thoughts.
Yes, I do, Julie. Good morning. First of all, it's amazing to me that a counselor felt that it was important enough to have this child searched that the vice principal was asked, and yet she declined. And her answer was, he has small pockets, as if somehow small pockets can't conceal a gun of this nature, which is absolutely false, and we're seeing that play out. So it's just really surprising with all of these red flags and indications that more wasn't done to prevent this horrible, horrible tragedy.
Jen, I want to ask you a question, please, about the 6-year-old, because you've seen a lot in your career and made a lot of arrests and worked a lot of cases and trained a lot of people on the range. It blows my mind that this 6-year-old wasn't nervous, to take that gun, put it in his backpack, pull it out, transfer it to his pocket, conceal it for a while until he found the perfect moment to confront the teacher and pull the trigger. I'm astounded that a 6-year-old child had the wherewithal to do that. Your thoughts, please, Jen.
Well, I'll tell you, Julie, in this day and age where you have video games where kids are shooting it up all the time, I also think this reflects his background, his home environment, his seeing guns, his being comfortable around guns, because he has seen that throughout his early life. But I agree with you, 6 is so young. I recommend at the age of about 12 to familiarize your children, if they are going to be around guns and you have them in your home, to take them to a range to make sure they understand and respect the weapon. But 6 years old, that's kindergarten. It's unbelievable.
Yes, well, I'm glad to hear you say that, Jen Coffindaffer. So glad you're here for this case.